Oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-1027. United Food and Commercial Workers Union, Local 400 petitioner versus National Labor Relations Board. Ms. Jarrett for the petitioner, Ms. Rajapaksa for the respondent.
Good morning, counsel. Ms. Jarrett, please proceed when you're ready.
Thank you. Good morning, Your Honors, and may it please the court. Amanda Jarrett on behalf of petitioner United Food and Commercial Workers, Local 400. In this case, the National Labor Relations Board overlooked critical evidence demonstrating that the employer excluded a union organizer from its premises in a manner that singled out the union's protected message for disfavored treatment and thereby violated the National Labor Relations Act. In April 2015, a union organizer accessed the parking lot of Kroger Store 538, where Local 400 had long represented store employees. The organizer sought to urge customers to support union members who were seeking the opportunity to transfer to two nearby Kroger locations because Store 538 was closing. While Kroger's lease with the shopping center where Store 538 was located contained a no solicitation, no loitering rule, Kroger had in the past tolerated a range of solicitation and distribution on its premises. In this case, however, Kroger chose to exclude the union organizer from its premises, and it did so in an unprecedented fashion. Kroger invoked a March 2014 letter from its landlord, which it had never used before. That letter issued on another occasion when the union planned to access the parking lot to disseminate a message protected by Section 7 of the Act. That letter empowered Kroger to have the police respond to protesting and disruptive activities, explicitly including those involving a labor union. Although the administrative law judge found the March 2014 letter relevant to the complaint allegation that Kroger selectively and disparately enforced access restrictions in a manner that interfered with Section 7 activity, the board looked past this straightforward evidence of unlawful discrimination.
Can I ask you a question at the outset, which is that the way the board conceived of these arguments is that there's two separate claims that could be raised. One has to do with Sandusky Mall and the board's decision to revisit that line of decisions and come forward with a new rubric. And then the other is the motive-based claim that it sounds like you're focused on here and what your briefing is focused on. And as to the latter one, first of all, it seems to me that you agree in your briefing that those are distinct ways of looking at the scenario. And there's a question raised about whether the motive-based claim is properly before us because it wasn't raised by you before the board, and there was no motion for reconsideration filed on that ground. And so under 160E, the board has argued that that's not properly before us. Can you address that?
Yes. So the union's position is that the complaint alleges that Kroger, by selectively and disparately applying access restrictions, interfered with Section 7 rights. And the union at all points during this litigation and the general counsel at all points during this litigation found this 2014 letter that we identify in our briefing and which I was just referencing in my opening remarks. This letter was relevant to the question of whether Kroger selectively and disparately applied access restrictions because of the circumstances surrounding its issuance, its wording, and its history of not being enforced. The union was not required to file a motion for reconsideration because the relevance of that letter was urged both before the administrative law judge and the board. The board had adequate notice of the argument that the union is now advancing on review and rejected it, finding instead that the letter would only potentially be relevant to an allegation of an unlawful promulgation, which is not something that was raised in this case.
So, but as I read our decisions, we have this as an HCA Corporation versus NLRB, and the language of that decision says, a party may not rely on arguments raised in a dissent or on a discussion of the relevant issues by the majority to overcome the Section 10E bar. The act requires the party to raise its challenges itself. So the fact that it was before the board in the sense that the board addressed it, the dissent discussed the argument in some depth, and then the majority engaged, at least in footnotes, and then decided not to treat with it, that it's from the language in HTH, it's not enough that the board had the argument before it in that sense, it requires that the party raise the challenges itself?
So the union's position is that, much like in this court's decision in the American Postal Workers case, there was both discussion in the underlying administrative law judge decision and in the briefs before the board that was in both the general counsel's brief on cross-exception and in the union's brief that this letter was raised, and it was relevant to the question of whether there was a selective and disparate application of the access restriction. And so it wasn't simply that the dissent raised the issue and it wasn't present in the case before. The board also opens itself, I think, to this issue by, in the fifth footnote of the decision and order, discussing the fact that in a case like this, where there is some indication that the purpose of Section 7 activity and the union's message itself is potentially relevant even under the standard the board announces. So I think overlooking the evidence that the union raises in this appeal is a real problem.
But the fact that the evidence, and one more question along these lines, the fact that the evidence, the letter might be relevant to something doesn't mean that the argument was raised. I mean, it's true that you can use evidence in service of many different propositions, but the question, it seems like under our decisions, is whether the challenging party now put forward that argument before the board. And it doesn't seem to me that you dispute that the union didn't put forward that argument. Your position is, and I understand it, your position is that, well, regardless, we're relying on evidence that all of us thought was relevant, and the argument was before the board. But I take it you don't dispute the proposition that the union didn't put forward that argument before the board.
I mean, the union referred to the letter both in its brief before the board, and the general counsel certainly in its brief on cross-exception raised the point.
But referring to the letter doesn't mean making the argument about motive. There's the other argument that was made, and as to which the letter might be relevant too. But it didn't seem like in your briefing or today, and I'm not saying you necessarily lose because of this, I just want to understand the position that you're taking, that you're not saying that we're okay because we in fact did make the argument. You're saying we're okay because the argument was before the board.
Correct. And I think the union's view is that the American Postal Workers decision that I referred to is a very similar type of procedural posture that this case is in. And I also just want to, take this chance to recast a little bit something that I think the board says in its brief that the union challenges, which is this implication that there are somehow two analytically distinct types of discrimination cases. And I think the union's view is that that's mistaken. There's only one kind of discrimination case, and this evidence was relevant to the complaint allegation. And, we only need to get into the kind of analysis the board did here, where we compare all the history, as in the Sandusky Mall line of cases, when we don't have the kind of evidence of discriminatory motive that's present in this case. This is really that kind of rare, easy case where we have a much clearer story of discrimination. And for that reason, even accepting that the letter was one of several factors that was discussed at earlier phases of this case, it's a very important one, and the board should have at least treated with it. Just to sort of return to that point a little bit, the union's view is that this March 2014 letter's wording, the circumstances of its issuance, and its unprecedented use to exclude the union organizer had to be relevant to the board's discrimination analysis. In most cases, it's difficult to ascertain whether an employer's decision to treat union organizers differently is rooted in animus. And that's why the board typically engages in a more searching type of inquiry. But whereas here we have evidence that very clearly indicates animus, that ends the inquiry.
What is the evidence? The evidence is what? One line by the former employee who said that he believed that the letter was prompted by a desire to keep the union organizers out of the property. Is that it?
I think that's one important piece of evidence.
What was the basis for his belief?
Because he was a store manager at the time and knew about the union's plan to engage in a similar type of solicitation that occurred in this case, and that was the response to.
But he didn't say he knew. He said he he just said he believed, and there's one line, and that's it. You talk about overwhelming evidence. I hardly think that's even substantial evidence.
With respect, I think it's important to note that it's uncontradicted evidence, and there was no effort to try and articulate any other justification on Kroger's.
Why bother contradicting it when the general counsel wasn't even arguing that motivation was he said there was only one issue, and that was disparate treatment.
Again, I think this question about whether there's one issue or two is an important one for the union. And our view is that, in fact, this complaint allegation, which is selective and disparate enforcement, the question of why the employer selectively and disparately enforce an access restriction is relevant. And, under the 10th Circuit's decision in the 4B case and other decisions like that, the board has to take that into consideration, because what Section 8A1 of the Act prohibits is interfering with protected activity and with singling out the union's message for disparate treatment. So it's not just that one line of testimony that we're talking about, it's also the wording of the letter. It singles out unions explicitly. It doesn't cast its prohibitions in general terms, and it talks about protesting and disruptive activities. There's no indication of any other groups that tried to access the property for those reasons. I see I'm at time, but I'm happy to answer more questions.
My colleagues don't have any further questions for you now. We'll hear from the board, and we'll give you a little bit of time for rebuttal.
Thanks.
Ms. Rajapaksa.
Thank you, Your Honor. May it please the court. My name is Milakshmi Rajapaksa, and I'm counsel for the National Labor Relations Board. The board resolved the single issue in this case, which was whether Kroger discriminated within the meaning of Babcock by allowing non-employee charitable and civic organizations to solicit on its leased premises, while denying access to a non-employee union representative who sought to encourage a boycott of Kroger stores. The board resolved this issue in favor of Kroger, and after reconsidering and revising its understanding of what it means to discriminate by allowing other distribution in the language of Babcock, the board dismissed the complaint. In the present appeal, as I understand it, the union does not challenge the board's revised understanding of Babcock and what it means to discriminate by allowing other distribution. Instead, the union claims that the board could have withheld judgment on the issue of disparate treatment that was specifically litigated, and could have instead found a violation on a different ground, that Kroger allegedly acted with anti-union animus. And the problem with this argument is sort of twofold in terms of procedure. The general counsel in the litigation below never suggested that there were two independent grounds for finding an unfair labor practice in this case. The general counsel at all times argued that Kroger engaged in disparate treatment under Sandusky Mall, which was a case interpreting Babcock. And so to the extent that the union is now proposing a different path to find a violation, it is literally adding to the general counsel's theory of the case, which is something it cannot do under Section 3D of the Act. The further procedural problem for the union is that it never raised this alternative path to a violation before the board, and it certainly could have done that after the board's decision issued and it became clear that the board viewed this as a pure disparate treatment case under Babcock. That was the moment when the union could have and should have told the board, no, you've misconceived the issue of discrimination before you. It encompasses, as Ms. Jarrett has said, more than simply disparate treatment. That was the moment for the union to raise that issue. And I do have to disagree with the union that this argument was before the board on exceptions. It was not. If you look at the briefing before the board, you'll see there was no separate analytical path outside of disparate treatment that was presented to the board. So there may be evidence that was raised in the litigation before the board, but the evidence was used for a different purpose. And so for both of those reasons, I would say that the court should not reach the union's argument. If it does reach the merits of the argument, though.
Can I just ask one, before you get to the merits, just one question on the procedural arguments you've raised. So suppose that the suppose, and I know you'll disagree with this premise, but I'm just interested in exploring it. Suppose that we think that the general counsel at least put forward this strand of the argument, the motive strand of the argument. At least it was sufficiently within the rubric of what the general counsel was urging, but the union never did. And then the board, in its decision, the dissent, of course, addressed the issue. And then the majority responds and says, A, that issue is not properly before us, and B, even if it were, we would disagree on the merits. That's what they say in footnote 23, I think. If that's the scenario, then do you think that the union is out of luck procedurally because they didn't file a motion for reconsideration? Or do you think the fact that, by hypothesis, the general counsel put the argument before the board is enough?
I think the requirement of Section 10E is that the union, the party, has to urge the objection before the board. So technically speaking, the union cannot rest on the idea that it was vaguely before the board or that another party had raised it. The board's position would be that the union itself had to raise the argument before the board.
How do you get that out of 160E? It's written in the passive, as if it doesn't matter who makes the objection as long as the objection has been made. So why does it have to be the union? Why can't it be the general counsel?
Well, Your Honor, I disagree that that 160E clarifies this, but I think
no objection that has not been urged before the board, etc., shall be considered by the court. Well, it doesn't say who has to raise the objection.
Right. I believe the cases show that there is an affirmative obligation on the party advancing the argument to affirmatively urge its argument before the board. But even if somehow the general counsel had raised this, which again the general counsel did not, there still is a question about whether this is an argument that was fully litigated before the board. There may be some vague way for the union to say that the general counsel raised this, but there is still a question about whether it was fully and fairly litigated as an alternative theory, and the board believes that it wasn't. In terms of the substance of the union's animus argument, the letter on which the union relies was issued by Kroger's landlord, and there is simply no basis in the record to attribute the letter or any animus that may lay behind the letter to Kroger. In addition, the letter on its face, contrary to what the union says, did not discriminate or single out unions for different treatment. It said that any picketing, demonstrating, and related disruptive activities on the premises would be prohibited whether or not involving a labor union. And finally, Kroger's use of the letter doesn't suggest anti-union animus, because Kroger used the letter in a circumstance where it was presented with protest activity that fell squarely within the ambit of the letter. And there's no surrounding circumstance that would suggest that Kroger's use of the letter was motivated by animus. Kroger had never permitted anything on its property like this boycott activity that the union was attempting to conduct. And so for all of these reasons, the board believes that the court should not address the union's legal argument about motive because it was never presented to the board in the first instance. But even if the court were to reach the argument, it should find an agreement with the board in its brief that there is no evidence of anti-union animus that would compel the board to find merit in the general counsel's complaint.
So is your position on the merits that there's no evidence of anti-union animus, or that there's no evidence at all? Because there is the testimony that the ALJ credited about the origination of the policy, right?
Right. There is testimony in the record from one manager about his belief that the letter issued in response to union activity on the premises, but there's no detail as far as the basis for that belief or any reason to think that Kroger was involved in the genesis or issuance of that letter, that manager literally presented one sentence of testimony on this letter, and it was very vague. So certainly, although there may be evidence that one could cobble together from this record that might suggest animus, it is certainly not evidence that would compel a finding of animus, which is what the union is suggesting. The board did actually address much of this evidence in the course of its response to the dissent, and its discussion really shows that there is no reasonable basis on this record to conclude that Kroger acted based on anti-union animus.
You're talking about the discussion in footnote 23?
Yes, I am. Yes.
Can I ask a question? And that is it in the record whether this letter went to the other tenants?
That I don't believe that's in the record, Your Honor.
Okay.
Yeah.
Is it in the record that there are other tenants?
Yes, that is in the record.
Okay.
There are several other tenants of this shopping center. If the court has no further questions for me, I would respectfully request that the court deny the union's petition for review. Thank you.
Thank you, Ms. Rajapaksa. Ms. Jarrett, we'll give you 2 minutes for rebuttal.
Thank you, Your Honor. The board's effort to articulate two analytically distinct theories of discrimination is erroneous, and this has an effect on both the procedural and substantive arguments in the case. In the union's view, this case turns on the board's failure to take account of evidence showing that Kroger's decision to exclude the union from its property, far from being a neutral act taken pursuant to generally applicable access restrictions, was instead an effort to suppress the union's message and thereby interfere with activities protected by Section 7 of the National Labor Relations Act. In the union's view, the essence of a Section 8A1 violation is to treat the union differently, and based on longstanding precedent, when a property owner like Kroger does something inconsistent with its practice, and as it did in this case, invokes a letter which by its terms, on its face, singles out the union for different treatment, and which has never been invoked against any other of the many non-employee groups that sought to access the property to engage in similar activities, that constitutes discrimination under Babcock and Stowe Spinning and the earlier line of NLRB cases that form the basis of the discrimination exception. Because the board's decision to overlook this evidence, which was properly before it and which taken together shows that what appeared perhaps to be a neutral property restriction was in fact a vehicle designed to empower Kroger to target the union and to take action against it that it had never taken against any other groups, the board should have dealt with that evidence. Now, the union's position is not that this court can find on the basis of this alone that the board's decision was wrong. This court should remand the matter to the board so that it, in the first instance, can weigh the significance of the letter, the circumstances surrounding its issuance, and the history of its selective enforcement, because it's that evidence which the union believes is essential to whether the complaint allegation stands or falls.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 20-1299, Secretary of Labor, Mine Safety and Health Administration petitioner versus Nighthawk Coal, LLC, and Federal Mine Safety and Health Review Commission. Ms. Scott for the petitioner, Mr. Moore for the respondents.
Good morning, counsel. Ms. Scott, please proceed when you're ready.
Good morning, and may it please the court. Emily Toller Scott for the secretary. I reserve 2 minutes for rebuttal, please.
Sure.
Established principles of administrative law support applying arbitrary and capricious review to the secretary's plan suitability determinations. Affirming the commission's decision in this case would require this court to contradict not only those principles, but also its decision in Prairie State, introduced without any basis a new element of proof to arbitrary and capricious review. The court should reverse the commission's decision and reaffirm that arbitrary and capricious review, that is, genuine arbitrary and capricious review, not the nominal version that the commission applies to MSHA's plan suitability determinations. It's true in this case that the commission said that it applied arbitrary and capricious review to the secretary's decision that Nighthawk's ventilation plan was not suitable. But saying that the commission was doing something is not the same as actually doing it. And the commission's using the kind of magic words of arbitrary and capricious review doesn't mean that it actually applied that standard correctly. Instead, what the commission did was introduce a new requirement, what it called a proof of plausible harm to arbitrary and capricious review. And that's a legal error for a number of reasons, and it's not appropriate in arbitrary and capricious review. So the first of those is that there's no basis in any of the case law on ventilation plans specifically.
Can I ask a threshold question about the review standard? Let's assume that the commission reviews what the secretary did under arbitrary and capricious review, and then which is what both parties are assuming. Then my question is, what is the standard by which we review the commission's determination that the secretary acted arbitrary and capriciously? And it looks like in the respondent's brief, they indicate that the question for us is whether the finding that the secretary acted arbitrary and in an arbitrary and capricious manner is something we review for substantial evidence, as opposed to whether we review de novo whether the secretary acted in an arbitrary and capricious manner. And I thought that that's what they're arguing in their brief at page 19. And I didn't see in your reply brief that you thought differently. But
no, that's correct. I agree that substantial evidence is the standard of review for the commission's finding about whether the secretary acted arbitrarily. But that's distinct from the legal question of whether the commission actually, in fact, applied arbitrary and capricious review correctly, if that distinction makes sense.
I'm not sure. It may make sense, but I'm not sure I follow it. And I guess my question is, for our purposes, when we're reviewing what the commission did, are we asking, was the commission right, de novo, to think that the secretary acted arbitrarily and capriciously? Or are we asking, was there substantial evidence supporting the commission's determination that the secretary acted in an arbitrary and capricious manner? And I guess what that gets to is the determination that the secretary acted in an arbitrary and capricious manner, is that a question of law that we review de novo? Or is that a finding of fact that we review for substantial evidence? What's your view on that?
Our view is that that's a substantial evidence question. That's the approach that the court took in Prairie State. So in Prairie State, the court considered first the kind of threshold legal question of what standard of review applies at all de novo, but then considered whether the commission's finding in that case that the secretary did not act arbitrarily was supported by substantial evidence. And I think the same breakdown should apply here.
This is less than a question and more an observation, but this system, I'm baffled by it, just like our chief judge is. Because, there is a line of cases in our circuit in administrative law that says the arbitrary and capricious review is the same as substantial evidence review. And so if you frame it up, it says that, and this is the statute says that the commission has to review the ALJ by a substantial evidence test. And then the judicial review provision of the statute says that we review the commission by a substantial evidence test. So you wind up with a system that says that the ALJ determines whether the secretary had substantial evidence to support, and the commission has to accredit the ALJ by substantial evidence, and we have to credit the commission by substantial evidence. It's totally, absolutely bizarre. That's not a question.
Well, Judge Randolph, I would just point out, one thing. I think, the commission's law is generally that ALJs, at least in the first instance, in most cases, apply a preponderance standard. Now, I understand that these plan dispute cases are very different, obviously, from your run-of-the-mill enforcement cases that the commission hears. But
I mean, I'll try to ask a question also, because I have the same kind of complex of concerns. It seems there's something a little bit odd about saying that we review a determination as to whether the commission, the secretary acted in an arbitrary and capricious manner for substantial evidence, because it indicates that that's a question of fact. And I just, whether the secretary acted in an arbitrary and capricious manner feels to me like kind of like a mixed question of law and fact, that's ultimately a legal conclusion that the secretary acted in an arbitrary and capricious manner. It seems like that's a legal conclusion that's grounded in facts. Of course, we have to consider, the reviewing body would have to consider the underlying facts to reach the legal assessment of whether there was an arbitrary and capricious deficiency. But it seems a little bit odd to say that we apply substantial evidence to the question of whether the secretary acted in an arbitrary and capricious fashion. But you seem to be buying into that. And I think that makes it harder for you, I think, right? Because I mean, it would be easier for you if we reviewed that de novo. I'm not necessarily saying that's right or wrong. I'm just saying I'm somewhat puzzled by the questions on this, because I don't completely know what the answer is.
I apologize if I've sort of muddied these waters or not provided more clarity. I think our position was simply that, you know, applying kind of the framework that was applied in Prairie State, the factual findings that the commission made to support its ultimate conclusion of arbitrariness would be reviewed for substantial evidence. So,
that's definitely true. But
right.
Then the determination that the secretary acted in an arbitrary and capricious manner, what standard of review do we apply to that? Because that's what you've put before us. You're saying the commission was wrong to conclude that the secretary acted in an arbitrary and capricious manner. And we could review that de novo. We could just step into the shoes of the commission and say, well, we'll look at what the secretary did and we'll decide de novo whether the secretary acted in an arbitrary and capricious manner and whether the commission was right to conclude that the secretary did. Or we could do something more deferential towards the commission. And we could say, well, actually, we don't review de novo whether the commission was right to conclude that the secretary acted in an arbitrary and capricious manner. We're going to review that deferentially. Maybe we think it's a question of fact as to which we apply substantial evidence review, which is, I think, what the respondent is saying, and which I didn't take you to be disputing. But that seems like a steeper climb for you than if we were reviewing it de novo.
I agree that it is a somewhat steeper climb, but let me step back to I think the underlying question. So yeah, I mean, yes, I think that at least it is in some respects a mixed question of law and facts. But you know, at least in resolving this case, you know, I think whatever standard the court applies, the commission's decision can't stand. And this is ultimately because MSHA's decision, I'll use MSHA and the secretary interchangeably here just to try to clear up any confusion.
Mm-hmm. Okay.
But MSHA's decision that this plan was not suitable is, you know, eminently reasonable and supported by the evidence that was before MSHA at the time. And this is, you know, primarily concerned with two issues. One was the deep perimeter cuts, which were not adequately ventilated, and the other was the inadequate weekly examinations that mine examiners are required to do. So, you know, fundamentally what MSHA found about these deep cuts on the first point is that deep cuts are more difficult to ventilate generally. That's especially true when they are dead ends, like they are in this case. These deep cuts in particular were difficult to ventilate because, again, they're dead ends. They're not connected to anything else in the worked out areas. They're unbolted. There are no roof bolts put in the roof, which keeps it from collapsing. So you have these deep cuts, which are inherently more unstable. They're not bolted, so they're even more likely to collapse. And roof collapse is one of the things that is most likely to release methane, which of course is one of the sources of catastrophic and fatal mine explosions. So here you have kind of a combination of factors that makes these perimeter cuts exceptionally dangerous. And that's one of the concerns that MSHA had in this case. It was not arbitrary. It was in fact eminently reasonable for MSHA to say to Nighthawk, well, you know, you need to tell us how you're going to ventilate these deep cuts, or alternatively, you can take shorter cuts, you can take 20-foot cuts, or you can just one of these two is what we need from you. And MSHA didn't get anything from Nighthawk on that, despite 10 months of asking for it. MSHA really didn't get anything from the operator that was going to address those deficiencies. And then the second reason that MSHA was concerned about this plan was again the inadequate weekly examinations. So a mine examiner has to, what's called walking the bleeders. Essentially, a mine examiner has to go through these worked out areas at least once a week and determine, take measures of methane and determine whether the ventilation plan is in fact working like it's supposed to. And MSHA found that there were a number of deficiencies in this plan that made it not possible for the examiner to really figure out whether that was going on. One is, generally these areas was not controlled. It was sort of intermittent. And again, the point of requiring these exams is to make sure that every part of these worked out areas is ventilated. So you need air to get into each place in this worked out area to ensure that you don't have pockets of methane, because again, those can accumulate and cause explosions. So
Scott, can I interrupt you? Because I just want to make sure I get my question in the way I view this case, and that is, it has very special circumstances in that this perimeter cut scheme had been approved repeatedly, and the vent study to me doesn't show any changed circumstance. To me, it's a unusual in that there have been past approvals, and at least until you point me to what circumstances have changed, there are no changed circumstances, and it was arbitrary and capricious for MSHA and the secretary to say, no, based on the vent study alone, I'm not looking at the other bases for the commission, but based on the vague, inconsistent vent study, it was arbitrary and capricious to vacate this perimeter cut in view of the past approvals.
I don't think it is, Judge Henderson, for a few reasons. So one is that, MSHA didn't decide to revisit this plan for no reason at all. What prompted MSHA's revision, or what prompted MSHA to go look at this plan again, was another mine in the same area, Gateway North, wanted to do something very similar to what this mine was doing. So MSHA, before it approved 40-foot cuts in that case, at that mine, excuse me, MSHA did a ventilation study there and discovered that those cuts were not being adequately ventilated. And so it was the findings from that ventilation study, essentially, that a very similar plan was not functioning adequately, was not suitable, that prompted MSHA to go look at this mine. And I don't think that was arbitrary, because there were so many similarities between the plans and the mines here. Additionally, I don't think that
Was it Gateway, the roof collapse caused by the bolt?
I apologize, Judge Henderson, I'm not following the question.
All right. What happened in Gateway that made them look at Prairie Eagle?
Oh, so Gateway had been using shorter perimeter cuts, but they wanted to begin using 40-foot perimeter cuts, like the cuts that were already being used at Prairie State. So
all right.
MSHA approved them in that case. MSHA did a ventilation study at Gateway to determine whether those deep cuts could be approved there. So that was the basis for starting this. Now, I would agree that if you had a plan at a mine that had nothing to do whatsoever with, or was completely dissimilar. I apologize. I see I'm out of time.
Go ahead, answer.
So if MSHA had if MSHA's only information was from a plan that was completely dissimilar to this mine, had nothing whatsoever to do with the mining conditions or ventilation system that was in use at this mine, that would be one thing. But here, again, MSHA got information about a mine that was proposing to use a very similar plan. And for those similarities, I think support support the reasonableness of MSHA's decision here to conduct this ventilation study. And just one quick final point. The MINUT contemplates that MSHA will revisit these ventilation plans. MSHA is required to look at them by statute at least once every 6 months. And so, yes, it's true that this had been approved in the past, but that doesn't tie MSHA's hands about whether it has to be approved in the future. And holding that it's arbitrary for MSHA to do that, largely on the basis that it had been approved in the past, I think would be contrary to the statutory design and would really make it difficult for MSHA to respond to new information about threats to minor safety and health.
Thank you, Ms. Scott. If my colleagues don't have any further questions at this point, we'll hear from the Respondents' Counsel. Mr. Moore?
Yes. May it please the court, I'm R. Henry Moore. I represent Nighthawk Coal in this matter. I think it is important to keep in mind when we're talking about this case, leaving aside the fact that this had been repeatedly reviewed and repeatedly approved over the years, is that this is a worked out area. Miners do not enter it after it is mined. And the typical way you evaluate a mined out area is you see what air is going in and what air is coming out. And that was, as Mr. Hassenstab described to the judge, that is exactly what was being done.
I thought, am I wrong? I thought with perimeter mining that with worked out areas, there's still exposure in a way that there's not with non-perimeter mining.
No, I don't believe that's the case. Yes, you can go in because the roof is supported in many of the areas, although not in the perimeter cuts themselves, but you don't normally go in because you've mined it out. You are looking to see if that area is ventilated by checking what goes into the area and what comes out of the area. And that's what they were doing. Now, one of the things about that study that they did, and we have to recognize that all three of the mines that they studied were the only mines doing perimeter mining at that point, although Gateway North had a predecessor mine, Gateway, that did perimeter mining. However, when you look at that study, there are a couple things that really strike you, which should have struck the district manager. First of all, the methane levels, even in the extended ends of the perimeter cuts, were minimal, 0.1% of methane or less. Those are very good numbers. The other thing that was striking was the oxygen numbers. When you expose coal to air, it begins to oxidize. What happens is it uses up oxygen. If you were not getting an air exchange, as Mr. Hartzog, our expert, described, across that worked out area, you would be seeing lower levels of oxygen. You were not. What hasn't been mentioned here, of course, is that we're talking about what the district manager considered so far. Well, what he didn't consider was the safety benefits of perimeter mining. Perimeter mining has distinct safety benefits that nobody disputes here. And he did not consider them. And the judge made a credibility finder when he said, oh yeah, I thought about them. Well, he didn't even mention them in any of his letters to them. These safety benefits are significant. They are obviously worth considering. We cited the Canyon Fuel case where involving an escapeway and suitability determination where the judge hadn't considered the safety benefits.
May I interrupt you?
Sure.
The usual situation with an agency decision that is reviewed for arbitrary and capricious is there's some sort of written opinion. But here, the secretary it wasn't a formal adjudication. Is the rationale, the secretary's entire rationale consists of the letters? Is that it?
The letters and the technical citation that was issued to give the commission jurisdiction.
That's it. Okay.
That's it. It's while a ventilation or roof control plan ends up with something akin to a mandatory standard, which is why it is worthwhile looking at the safety benefits when you are analyzing the plan.
Well, let me follow up on that. Do you read the correspondence back and forth and the citation as meaning that, okay, your ventilation plan was maybe okay, but ours is better?
No, I don't read it that way. I think I would like to read it that way in a sense, but no, I'm reading it as they thought ours was bad and shouldn't be used at all. And I don't think that's really should be the case. They permitted Nighthawk to use it for years. They permitted other mines to use it. As Mr. Esslinger, a former 30-year MSHA employee, said, other mines have been using this. It is a very safe method of doing it.
Yeah, but the agency can change its mind, can it?
Well, the agency can change its mind, but it has to be reasonable when it does that. And one of the things they didn't do here is look at the safety aspects and balance it out. This court over the years, and I know Judge Henderson's been involved in some, has dealt with petitions for modifications of mandatory standards. And one of the aspects of those that you look at is whether or not there are safety advantages irrespective of what the standard provides. And in this particular case, there are distinct safety advantages from a standpoint of avoiding hazards of roof bolting, a standpoint of respirable dust, which is specifically a purpose of a ventilation plan, moving equipment, and the like. There are significant safety aspects that the district manager just simply ignored. Excuse me. But we look at some other things here. It's not only failure to look at the safety aspects. One of the things he didn't do is talk to his own inspectors. This district manager did not have any experience with perimeter mining. He said he'd been in Nighthawk, but he'd never looked at perimeter mining. He's got a number of inspectors who inspect this mine regularly, ventilation specialists and the like. And he never sat them down and said, what do you think of this? His excuse was, well, this wasn't a plan revision, this was a revocation. I find a revocation to be a major form of revision, if you want to know the truth. The excuse is, well, they were part of Mr. Biter's team. Well, apparently he didn't talk to them. But given how he reacted when he disagreed with one of his subordinates who was doing smoke tests, I'm not surprised that he didn't talk to them. They didn't talk to those people who we have evidence supported perimeter mining. We also, this is what normally when you have a worked out area, the roof is bad, the atmosphere is bad, and you can't go in there and do the sort of thing they did here. But they have techniques to evaluate airflow across a worked out area using tracer gas. Mr. Biter and I discussed measuring the pressure drop across the worked out area. They didn't use that. It would have been really simple to use that. Well, not simple because you have to set up a tracer gas study, but they didn't do that. And this whole thing about the smoke test, recognize that what we're talking about. I am standing in a dark mine entry with a cap lamp, and out in front of me is a wheeled device I've wheeled out into the end of the perimeter cut with, I think they said 2 cap lamps on it. And I'm sending puffing smoke out there and trying to figure out what it's doing. And what it did was dissipate, which would suggest to me there was some air movement. They also took bottle samples from that area, which showed the methane was low and the oxygen was good. But if you look at the smoke tube tests, they are suspect right from the get-go.
Can I ask you a question about this, which is it your view that the Secretary's determination, or MSHA's determination, I can't remember who exactly made it, but that the nearby mine couldn't engage in the level of deep cuts that it engaged in suitable, that appropriately for purposes of ventilation, was also arbitrary and capricious? Or do you think that there's a difference between the circumstances involved with that mine and yours?
There aren't enough of the circumstances on the record, Your Honor, to say, but my gut feeling is all three studies, Gateway, Viper, and Nighthawk, are all similarly flawed because of the way they did the studies. One of the things I want to point out is we're talking about 40-foot perimeter cuts. Typical miner cut is 20 feet. Nighthawk would have had, as undoubtedly Gateway and Viper would have had, the ability to take 40-foot cuts that were not perimeter cuts. And when you evaluate for 40-foot cuts, you evaluate the ventilation at the end, because what you're doing is you're taking your continuous miner and mining for 40 feet. Well, it's a dead end no matter what until you make air connections. But because it's a dead end, when you are approving those, you actually do a ventilation study to see if it's ventilated properly at the end. You can see in the history of the ventilation plans here that the district views getting a 40-foot cut non-perimeter as a step-by-step process. That was true in the Prairie State case that was before this court also earlier, that you have to go and prove that you can mine 20 feet, 30 feet, and 40 feet. There was a comment also that you could have a roof fall, which would obviously, there are two types of liberation. One is, a sort of sudden outburst, and the second is a generalized liberation. We obviously didn't have generalized liberation in this worked out area because your methane wouldn't have been at the levels. Even if you had some roof liberate methane, which there was no indication that had happened in this area, you still don't have an ignition source. Mr. Hartzog testified that there was no ignition source in the perimeter cuts. You don't have the right type of rock. They're not bolted, so you don't have that argument, which is because sometimes they've argued that roof bolts can spark, but that is not the case sufficiently to ignite methane, as I understand it. But you don't have the potential here that the secretary and the district manager did a parade of horribles that simply didn't apply to this area, to this mine. And one of the things that theoretically mine plans are supposed to be mine specific. And in this case, the mine specific nature, very low methane. There are other factors that you can look at here, and that one of the things is these panels of rooms where they were doing perimeter mining have about a 11-month life, because what they do is they mine the rooms and mine up 600 feet and then come back and seal off the area, which means they stop ventilation, but they also don't ever go back in there again.
How
Can I
long
ask
a time?
kind of a fundamental question that you say that miners don't go into these worked out areas. Is that correct?
That's correct.
Okay, so who cares whether it blows up or not?
Well, okay. You care about that.
The inspectors.
Well, the inspectors don't go in there either, Judge. Once you've mined it out and you are only inspecting the perimeter, the bleeder area, if you had a mine that was susceptible to methane accumulations, which this mine obviously isn't, you could have a methane ignition that would propagate out of this area, but you simply don't have either the ignition source because you have no electricity left in there, and you don't have the ignition sources from any other source. But you can theoretically have an explosion that propagates out of a worked out area. But in this circumstance, the methane isn't there.
All of the instances in which miners have been injured by methane explosions were they all ones in which the miners were in the area?
Yeah. I'm running through my mind, Judge Randolph. Generally, yes, because I'm thinking of like Upper Big Branch, the miners were on the Longwall face. Willow Creek, the miners were on the Longwall face. But there are varying circumstances over the years, but usually miners are in the area.
Well, let me ask you if I could, Mr. Moore. You said the inspectors don't go in, of course, after it's sealed, but does the record show the length of time between when the perimeter cuts are finished and when that worked out area is sealed, when the inspectors would go in? And
let me sort of answer in two parts. Once it's sealed, they don't go in, and it was about an 11-month period from the time they started one of these groups of rooms to the period when they would be sealed. The inspectors, even before it's sealed, when there is active mining, because they mine a group of rooms to each side and continue in that way, they don't go into the area that's been worked out and already mined. They visit the active mining area and they would inspect the bleeder entries around this worked out area. They would not go into the worked out area. In fact, there is some testimony that this was barricaded off so that they couldn't get into the worked out area. And there's nothing going on there, so there really isn't any reason for them to go. They go, frankly, where the miners are working.
Okay, but we don't know how long a period of time between the working out of the area and the sealing of it.
It's less than 11 months.
Okay.
But
is that in the record?
Yes.
Okay.
Yes, Mr. Hassenstab talked about it.
Okay.
But there is, just to clarify, pick up on what Judge Henderson was asking you, there is a difference between perimeter mining and non-perimeter mining in that there's a period during which, with perimeter mining, worked out areas remain accessible and not sealed, right? They ultimately get sealed.
Ultimately get sealed, but if we were not to perimeter mine around each one of these rooms, it would still be a worked out area, and the only place on that group of entries that you would go in is the bleeders around it to check that the air was moving across. You would not go into the worked out area, even if there were no perimeter mining. There is no reason to go into that area where there is no mining and the mining is finished.
Okay. My colleagues don't have further questions for you, Mr. Moore.
So I do have one. So does that mean that the worked out area, it's not possible to have a methane leak that either originates there or flows there?
I won't say it's not possible, but it is not likely. The active mining, which is where, if you were going to have methane liberated in any way, is further in by or further away from this worked out area. And you are checking the air coming out of the working where they're actually mining coal on a regular basis, and there are fairly low limits. So it is unlikely you would be getting methane there into this area.
But thank you.
Just to finish out this thought, but the secretary found that with the worked out areas in perimeter mining, there is the possibility of methane in those areas, right?
I think.
You just think that was wrong, or
Well, when you use the word possibility, Your Honor, probably anything is possible, but it is not likely. And that's what the testimony was. And actually what the district manager should have known, that it wasn't likely because they monitor the methane at the mine. Every quarter, they evaluate all the methane coming out of the mine at the fan. So they know what's going on.
Okay. If my colleagues don't have further questions, thank you, Mr. Moore. Ms. Scott, we'll give you the 2 minutes you asked for rebuttal.
Thank you, Your Honor. Just a few points to make. Judge Randolph, you asked one question about what the record on review is here. Given how the technical citation process works, I think Nighthawk wants to have it both ways, where it gets to testify at the hearing, the secretary only gets to rest on, the letters that it sent. So given how this process works, given that there was a commission hearing, the secretary's explanations provided at the hearing are also part of the agency record that are on review. And second, and this is the broader point.
Well, was it the secretary's position that even though the ventilation plan that the company proposed would have been sufficient, that the secretary demanded more?
The secretary's position was that this plan that was revoked was not suitable for the 5 reasons that were outlined in the technical citation that
That it was not adequate.
That's correct.
Okay.
And the broader point that I want to make here is picking up on what Judge Srinivasan just asked, which is that, fundamentally this case is about the commission simply disagreeing with the conclusions that the secretary reached. The question, though, on arbitrary and capricious review is, did the secretary make findings that consider the relevant factors? Did the secretary provide an explanation? And as long as that wasn't so inherently unreasonable that it can't possibly be the product of agency expertise, then it really should be affirmed on arbitrary and capricious review. And the commission's decision misses that point. Most of the points that Nighthawk has raised, they miss that point completely as well. And that's the fundamental problem with the commission's decision here, is that MSHA, the secretary, makes these policy calls about whether the plan is suitable. And that's committed to the secretary by the Mine Act, by his role in the Mine Act split enforcement scheme, and the commission's decision to the contrary should be set aside.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
There it is.
Case number 19-5272, OA et al. Versus Donald J. Trump as President of the United States et al. Appellant. Mr. Ruveni for the appellants, Ms. Zaharia for the OA appellees, Mr. Wright for the SMSR appellees.
Morning, counsel. Mr. Ruveni, please proceed when you're ready.
Thank you. Good morning, Your Honors, and may it please the court. And I'd like to reserve 3 minutes for rebuttal. Your Honors, plaintiffs, organizations, and individual aliens challenge a rule concerning asylum eligibility, a core and fundamental issue that is adjudicated in administrative proceedings and then reviewed in the Court of Appeals on a petition for review thousands of times a year. The district court, however, ignored the comprehensive, carefully reticulated claim channeling and judicial scheme that Congress put together in 1996 and revised in 2005. And found that because this case involves organizations as well as individuals challenging an APA, under the APA, a decision on the record, that cannot be channeled through Section 1252 into the courts of appeals. The district court was wrong. Many of the cases from this court, not addressing 1252, but claim channeling specifically, go into detail why, but the government's view, the court fundamentally misapplied the Thunder Basin framework. And even if there is jurisdiction, we think the organizations lack a cause of action, not within the zone of interest, and in any event, the government wins on the merits. So starting with jurisdiction, as we lay out in our briefing, 8 USC 1252 is a carefully circumscribed, specific claim channeling, and in some instances, claim barring provision of the INA In our view, it does two things that are relevant to this case. First, it channels all the individual aliens in this case, it channels their claims into the petition for review process. At the time this case was filed, all but one of the individual plaintiffs was issued a notice to appear, and so that triggered the administrative review process. At the time the court issued its decision, that last individual had also been placed in the removal proceedings, and so that individual's claim was no longer ripe to proceed in the district court. And as to the organizations, 1252 specifically provides for a cause of action only to individual aliens. It does not provide a cause of action to organizations seeking to allege claims or raise claims on behalf of third-party aliens. So whether or not the organizations may have organizational standing, the claim channeling scheme itself provides a cause of action for the aliens only. And I think starting with two of the fundamental Supreme Court cases on this that we cite in our briefs, specifically Block and Thunder Basin. I think just a quote from Block that the district court didn't address, although that we cited to the district court. This is at pages 352 to 53, 467 US. A statute that provides a detailed mechanism for judicial consideration of particular issues at the behest of particular persons. If the statute does it, I should say, quote, judicial review of those issues at the behest of other persons may be found to be impliedly precluded. And I think the district court and plaintiffs on appeal rely on the canon that there is a presumption of judicial review of agency action. And unless the statute uses magic words that say this claim by this plaintiff is barred, then the claim may proceed. But I think the lesson of this court's cases and the Supreme Court cases, and here I'm referring to Jarchesi and American Federation, both one from 2013 and 2019, on which I think each of your honors was a part of at least one of the cases in the decision. I'll point out that the opposite is true, that unless there's no magic words that need to be used in a situation like this, and that's because there is a vehicle for individuals to raise claims and vindicate the interests the statute in Congress has provided for. So the inference here is that the organizations have no claim unless and until there's something in the statute that suggests Congress intended them to have a claim.
So can I just ask about the individuals? If we start, just put the organizations aside for a second. With the individuals, given the Supreme Court's recent decision in the Regents of the University of California case, what's the argument that 1252b9, which is the main provision you rely on, I know you have some other ones too, but 1252b9 appears to be the main focal point of the submission. What's the argument in light of the Supreme Court's decision in the Regents case, which also involves some individuals at least, that even though that provision didn't preclude review in that case, it does preclude review here?
Yes, Your Honor. I think Regents is easily distinguishable, and Regents doesn't really advance the ball on this any more than Justice Alito's plurality in Jennings v. Rodriguez did, which is what the parties argued about in district court and in their first submission before this court, before Regents was issued. But Regents involved a facial challenge to the Secretary's decision to rescind DACA. And DACA is a separate benefit that provides work authorization, and it's basically non-enforcement against a class of individuals that is issued before any removal proceeding ever occurs. And it's not something that is provided for by statute or regulation that can be litigated in the removal proceeding. So once your DACA is rescinded, that's not something you litigate in the removal proceeding. And I think the key language in Regents, which didn't purport to be a all-encompassing analysis of 1252 because it wasn't the focus of the decision, but it says, quote, the process by which removability will be determined, quote. That's one of the at least three categories of things that are channeled into removal proceedings. And here, while plaintiffs say, both individuals and organizations, they're not challenging final orders of removal, and in a technical sense, that's true. They are challenging the rule of asylum eligibility, that asylum is relief from removal. So they are challenging the rule.
But what the Supreme Court said in that case is, and it's certainly not, the last paragraph the last sentence of the paragraph that discusses B9, and it's certainly not a bar, whereas here the parties are not challenging any removal proceedings. And here, I don't understand the plaintiffs to be challenging removal proceedings. It's true, I take your point that the challenge can be raised in the context of a removal proceeding. That I think is true. If somebody is subject to removal and then they seek asylum, they can, and then they face the ineligibility bar that emanates from the rule, they could raise the challenge there, but they're not challenging removal proceedings as such. They're challenging the ineligibility that comes from the rule combined with the president's action. And so it seems like it fits within that sentence. The argument would be that B9 doesn't pose a bar because there's not a challenge to removal proceedings, as is evidenced by, for example, somebody who would seek affirmative asylum and wouldn't be part of a removal proceeding, but would still be subject to the ineligibility bar.
So a couple responses to that, Your Honor. First, on the asylum point, there's affirmative asylum point. There's nobody in this case who has standing to litigate that.
But it
claim.
wouldn't be a
So
different case. I mean, it would still be the same challenge.
Well, I think I refer the court to, this is in our papers, the Seventh Circuit's decision in Dakal from 2018. So it's true that an individual who has an affirmative claim for asylum initially doesn't go before the immigration courts. But if that claim is denied, they then go before the immigration courts because the regulation provides that they are then subject to removal and they're issued a notice to appear. And in Dakal, the court said, well, look, because that option remains available, that's where the claim has to be litigated. And it may be that the government doesn't ever place the individual in removal proceedings.
Right.
That's a separate issue. That's not this case. And the court did address that there. It's not jurisdictional at that point. It's a non-final agency decision, interlocutory in nature, that then can be adjudicated finally in the removal proceeding.
So
and while it's true,
if we had a case that involved somebody who sought affirmative asylum and who wasn't subject to removal proceedings, and we don't know whether there would be a removal proceeding at the end of the day, because as you say, it's up to the government to decide whether to initiate one. Maybe they're even subject to DACA and it hasn't been validly rescinded at the time, but let's just suppose you have one. Would you still say that B9 poses a bar?
So a couple of responses to that too, although we didn't brief this in our briefs, but to answer your question. So first, we're not arguing B9 in that context. In the affirmative asylum case, we would be arguing finality and ripeness sort of issues. We would be arguing, and that's what the Seventh Circuit relied on, that the individual can still litigate this affirmative asylum claim, or challenge the denial of it, I should say, including challenges to the rule on which that denial was based in the removal proceeding. But I do think there's a line of cases, it's not briefed here, that provides that if there's no way to get into a removal proceeding, then you do have final agency action. And in that potential situation, you might have a claim in district court, but none of the individual plaintiffs fit that situation here. And so there's a disconnect between the district court's reliance on the possibility that an individual may have an affirmative asylum claim and its conclusion that then that means these individuals who are all indisputably in removal proceedings at the time the court issues its decision, they also don't have to raise their claims.
Where are the removal proceedings now? Is everything on hold because of the Ninth Circuit?
No, Your Honor. My understanding, so the rule just was enjoined and that was affirmed in the Ninth Circuit. So that means this particular rule cannot be applied so long as that injunction's in place to these particular individuals or anyone for that matter in removal proceedings. So, but the proceedings are ongoing. So a number of individuals have been granted asylum. Their claims are moot at this point. They have no real reason to challenge the rule anymore. And then the majority of the plaintiffs are still in removal proceedings and they remain ongoing.
They've all, I'm not really clear about this, but in these removal proceedings, has the issue whether these particular individuals are eligible for asylum, has that come up?
It has. They've all raised, many of them have raised defensive asylum claims as a defense to removal, but since the rule has been enjoined by the Ninth Circuit, or if that injunction has been affirmed by the Ninth Circuit nationwide, this rule cannot be applied to them. However,
in other words, they're eligible. They're not ineligible because the rule has been enjoined. So what I'm getting at is, have it's the immigration judges who make these decisions? Is that right?
Initially the immigration judge, and then depending on what happens, it's appealed to the board.
So
and then
with respect to all of the plaintiffs other than the ones who've already gotten asylum, has there been any judgment by the immigration judges about whether they are entitled, whether they qualify for asylum?
Yes, Your Honor. So not based on the rule, but as of our reply brief, 3 individuals had been found to warrant the grant of asylum and had received asylum.
What about the others? What about the others? What about the others?
So far as I'm aware, they have not yet been granted asylum. It may have been denied on other grounds, and the proceedings are still ongoing on that basis. So they would take an appeal up to the Board of Immigration Appeals, and then if they're unsatisfied with the result there, they would go up to the relevant Court of Appeals. But I think on that point, even though they're not are not necessarily directly challenging the rule right now in their proceedings. I think the teachings of the cases that we cite in our brief and the lesson here is they can raise that in the Court of Appeals because they're litigating their asylum claims. This would be relevant to their asylum claims. So if ever the rule is operative again, they can raise in the first instance to the Court of Appeals a challenge on the merits, on the legality of the rule, even if the immigration judge or the board cannot set it aside on their own.
So is this actually an exhaustion case?
Yes, Your Honor, that's the government's position. Because they are in removal proceedings now, they have to raise all their claims relevant to their removal in those proceedings. And there's a statute, section 1252D.
Are you familiar with our decision in a case called Avocados Plus?
I apologize, I don't believe I am.
Where we analyzed judge made, and the other is jurisdictional. And is 1252 or 92? Is that jurisdictional or is exhaustion judge made or jurisdictional?
So that's jurisdictional by statute. It's a mandatory exhaustion provision. We cite a number of cases from other circuits addressing that. I don't think this court has had the opportunity to specifically address 1252D. These cases are rare in this jurisdiction, but it's mandatory. It's a mandatory exhaustion requirement. And so 1252B9 plus D channel everything up on appeal. And if you don't raise the claim in that proceeding, you cannot raise it in the petition for review. We do cite a case.
Isn't there a provision in 1252 that actually talks about exhaustion?
Yes, Your Honor, that's 1252D. 1252 says you must raise your claims first in the proceeding and then following that on the Court of Appeal. So there's any way you look at it, you don't get into district court, particularly as an individual challenging your asylum determination. I am running short on time. I do want to touch briefly on a couple of other issues, unless there are other questions on this particular.
I have one quick one, and we'll let you touch on the other issues too.
Thank you, Your Honor.
But for the individuals who've been granted asylum, if you win ultimately at the end of the day on the merits, then are they at risk?
I think that depends at what stage their proceedings are in. If their proceedings are over and done, I think they're fine. If their proceedings are ongoing, so if no decision has been rendered yet on their case, then I think under general retroactivity rules, this rule can be applied to them in their proceedings because the proceedings are not final. But if the proceedings are final, I think they're fine. That's my understanding of how those cases work, at least.
Yeah, I was thinking of 1252 D, which says a court may review a final order of removal only if the alien has exhausted all administrative remedies, right?
Yes, Judge Randolph, that's the provision I was referring to.
I thought you said B. Okay.
Well, B9 zips up, in the words of the Supreme Court in Reno, all the issues related to that proceeding into that one petition for review. And unless and until you go through that process, you don't have any forum in federal court to raise these things. And then D.
So if in these removal proceedings, there's final orders of removal and the aliens did not raise the defense of asylum, then they wouldn't be entitled to raise it in court. Is that right?
I think that's right, Your Honor, but I think every single one of these individual, the named plaintiffs in the case are raising asylum claims. So this is not a situation where they're going to be blindsided by a ruling saying you should have done that. They've all raised asylum claims.
No, it wasn't. What I'm getting at is it wasn't optional. They had to raise it in the removal proceedings or they would lose it in response to judicial review of an order removing them, right?
Yes, Your Honor, that's correct. So any removal related issue, including relief from removal, which asylum is, would have to be raised first in those proceedings for these individuals. And even without the jurisdictional exhaustion requirement, I mean, it's just odd to be in this posture where a district court is parties are litigating in district court while the individuals are also in removal proceedings at the same time. That's precisely what the Congress sought to eliminate in 1996 and 2005 with the Section 1252 revisions on claim channeling. I am over time. I have another question.
I have another question. If an individual, let's suppose that the rule is upheld and the proclamation, whatever it is at the moment, is in force, and an individual crosses the border and is therefore, and not at a point of entry, but is therefore declared ineligible for asylum, does the Attorney General or the Secretary nevertheless have discretion to allow that individual to remain in the United States?
Not based on asylum, not on a finding of asylum, but the rule does not eliminate other forms of protection consistent with international treaty obligations that the Congress has legislated in 1231 and 1252 and other provisions.
What I'm getting at is I'm wondering if there's any function that is served by number one, having giving an alien the right to apply for asylum, and then number two, because of the operation of the rule and the proclamation, making the alien ineligible. Is the application for asylum, does that serve any function then?
Yes, I think it does. So a couple things here. First, this isn't just anyone who crosses the border. This is if there's a proclamation in place, and the proclamation, as we lay out in the brief in more detail, spoke to a specific point in time when there was just a mass of individuals crossing the southern border. The president and the administration thought there was an immigration crisis, and that's what this was responding to. Of course, those are facts from 2018 at this point, so 2 years ago. But the application itself, an individual doesn't just apply for asylum. When they seek protection from removal, they apply for asylum, withholding, relief under the Convention Against Torture, so those three types of relief. And so even if they're ineligible for asylum, they're still applying for withholding of removal and for CAT protection. And it's my understanding that most, if not all, of the individuals in this case are seeking such relief as well. But as to if Your Honor is asking what's the point of applying for asylum if you're categorically barred from being eligible for it, I think that's sort of a dispute within the panel in the Ninth Circuit in the East Bay case. That you apply, just because you are ineligible for asylum does not mean you're ineligible for those other forms of relief, but also the statute itself is structured that way. Many people are entitled to apply for asylum, including the 6 categories of individuals under 1158B2, for example.
Is that the
felons?
You're talking about
felons, terrorists, political crimes.
They can all apply.
A number of other categories. They all can apply, but they know with a certainty that they're not going to be granted asylum because the Congress has taken away the discretion of the Attorney General to grant asylum in those circumstances. And this is what the rule does here as well, in a much more narrow and cabin-specific point in time, 2018 November, where there's a record showing a large uptick of illegal crossings at the southern border.
But what seems different about this is it's of course it's true that there can be people who are ineligible even if they're allowed to apply. That is true of any dynamic that works this way. But what seems different about this is that the statute that spells out who applies specifically designates one consideration as not diminishing the ability to apply. And that's if you enter at a designated port of arrival or if you've been interdicted in international United States waters. It specifically says that those individuals can apply regardless of that fact. And then when the categorical rule of exclusion relates only to that fact, that's what makes this dynamic different than the other examples that you're identifying.
So I take the point, and I understand the question, but I think we would respectfully disagree with that. I think it's instructive to look back at what preceded this statute in 1996. The asylum statute and the Refugee Act in 1980 was similar. It provided that individuals may apply for asylum irrespective of their status. And then the board in 1987, in a case, matter of Pula, addresses what that really means. And what that means is you can apply for asylum regardless of whether you cross at a port of entry or illegally between ports of entry, or if the United States brings you here against your will or interdicts you on the high seas. But none of that means you're eligible. And so, yes, all that means is you can apply. And I think the other thing is, if you look at what Pula was doing, Pula responded, or pulled back, I should say, a decision matter of Salim from 1982, which did provide for at least 5 years until Pula that manner of entry can be an outcome determinative, dispositive factor in an asylum determination. And that was 5 years, and that statute allowed for it then. So the statute has the board reading it 2 different ways. And I don't think the 1996 amendments changed that in any fundamental way. What 1996 Act says is, okay, port of entry, not port of entry, either way you can apply. But that doesn't promise you anything other than potentially ultimate denial. And so the district court acknowledged that the government could do this case by case. It went so far as to acknowledge PULA allowing for that, but then it just says you can't make that a categorical denial. And I think the trouble with that from the government's perspective is the regulation 1158B2C does speak of in terms of regulations, and it doesn't say anything about it has to be case by case or not. There's nothing in the statute explicitly that says every asylum case must be adjudicated case by case in the specific facts of that case.
So suppose there's a rule that says nobody who applies for asylum is eligible for asylum for 5 years. Would you say, well, yes, you got to apply, and yes, the statute allows people to apply for asylum, and the fact that nobody gets it, that's whether you're going to get it ultimately. It doesn't have to do with whether you can apply for it.
So let me quibble with the premise of the question just a little bit, Judge Srinivasan, because we do have a provision 1158A2B in the application section of the statute that says you have to apply within 1 year. And we have another provision, A2C, which says if you've previously applied and it was denied, you cannot apply for asylum again. And then there's an exception for changed circumstances. But the statute does allow for that. So I think the question in your hypothetical would be, is a rule like that says, okay, you can't apply for another 5 years, is that consistent with the statute? And arguably it would be, because 1158A2C says if you've already applied and been denied once, you've lost your shot and you don't get to apply again.
Well, I'm talking about first-time applicants too. I'm not talking about somebody who already applied. I'm just saying it's if we just cut off eligibility at all and just say across the board, nobody's eligible for asylum. I mean, in theory, one could say, well, you still get to apply. It's just that, and the statute does allow people to apply for asylum, but the statute doesn't say that anybody who applies actually can get asylum. So we're just going to cut off eligibility for asylum, the argument would be, and there would be some metaphysical distinction between whether you were eligible to apply and whether you were eligible to receive. But the statute presupposes that people can apply for asylum. And
I'm sorry.
And one category that specifically can apply is people who arrive outside of a port of entry.
That's right, Your Honor. They can apply. But again, I go back to the statute and the discussion I just had with Judge Randolph. There are 6 categories that are all individuals who can apply. All those terrorists, particularly serious crimes, those bars, they can all apply, but they're categorically barred at the outset, but they can still apply. And there's a reason for them to do that. They can seek other forms of relief, like withholding or CAT relief. And also, I don't know that the statute is as crystal clear as the district court thought on this matter of entry application versus eligibility. There's another provision, 8 USC 1231A5, which provides that if you cross the border between ports of entry, so illegal reentry after having been removed, you are categorically barred from asylum. So it's not clear to me that Congress specifically said anyone, regardless of how they cross the border illegally, shall be eligible for asylum. And we're conflating eligibility and application here for purposes of your question, Your Honor. But Congress, in fact, said the opposite in that provision. It said cross the border illegally, you are excluded from asylum. So the statute doesn't seem to be unambiguous on that point. And if there's a provision that provides the government authority to render classes of aliens categorically ineligible for asylum, 1158B2C, unless there's something explicit in the statute that says manner of entry cannot be a basis for ineligibility, then I don't see the inconsistency. And we know manner of entry is not a basis, cannot be a basis for ineligibility, because Congress is legislating against the backdrop of 30 years of administrative law in these cases. And we have matter of PULA, which says weigh it this way. And we have matter of Salim saying, no, weigh it as an outcome determinative point. But in both cases, it's a relevant criteria.
Can I just ask one question based on one thing you said? You said the statute is not unambiguous. And I noticed that the government didn't ask for Chevron deference, which if you thought the statute was unambiguous, what was not unambiguous, then Chevron could potentially get you somewhere. And the Ninth Circuit did extend Chevron deference. And I'm just wondering, does the government think that the Ninth Circuit was wrong to do that? Or does the government have a view on that?
So you're right. We didn't explicitly ask for Chevron deference in our briefing. So I can't stand here before you or sit here before you today and say, actually, we want Chevron deference. I don't think we can waive it under this court's precedents. I think that's not something that the government the DOJ, the Department of Justice, can do. If Congress, if it's unambiguous, it's unambiguous. If it is ambiguous, it is ambiguous. All I meant to say is the statute. I think our point, our lead point, is the statute doesn't explicitly say manner of entry can never be a bar to eligibility for asylum. And I think we don't need deference to win on that point, but I don't think we can waive the deference argument if Chevron does apply.
I have a couple more questions. First of all, is eligibility for asylum a defense to a criminal prosecution for illegal entry?
It is not.
It's not.
It is not.
And is it accurate that the initial entry by an alien from other than a port of entry is a misdemeanor, punishable by 6 months in prison?
You can be charged for that for your first entry.
And if the same alien tries to enter again after being removed, it becomes a felony. Is that true?
That's correct, Your Honor.
Okay. If you take this scheme, the rule plus the proclamation, and apply it to the second category of illegal entry, the felony category, because it's 2 years imprisonment, then I don't think there's any argument that would be invalid.
No, I would agree.
Okay. Are you familiar with the Supreme Court's opinion in Reno versus Flores?
The 1993 case, Your Honor, involving juveniles.
It was an immigration case.
Yes.
By Justice Scalia. And he held for the court unanimously the following, that when a statute or when a regulation is claimed to be in violation of a statute, that the Salerno rule applies. You know what the Salerno rule is?
Yes, Your Honor. I think I know where you're going.
Okay.
And
which means
that argument.
Which means that with respect to the two-time offenders, that if that is a valid application of this regulation to those people, then the regulation, because it's only a facial attack, not as applied, and the petitioners and plaintiffs say that over and over again, that means that the regulation, we have to uphold that regulation.
I would agree with that, Judge Randolph. I would admit we did not advance that argument in our briefing, but let me take it in a slightly different direction. An argument we did advance in our briefing. That is exactly why these claims are channeled into petitions for review raised by individual aliens in those proceedings. It could be that the rule is not facially invalid, but as applied to an individual in a particular context in this particular place and time may be invalid on the facts of those cases. But here, I think it's instructive. Plaintiffs don't advance a due process argument. They don't advance an equal protection argument. It's a straight up statutory argument. And I take the point, and I think we certainly agree with it. Because they raise that as a facial challenge here, that because it can be applied lawfully to a large number of individuals, it can't be facially invalid. And so that again just proves the reason why this has to be channeled through the petition for review process, because there could be an individual who does have a viable or colorable due process or other constitutional claim, and that claim is preserved and can be raised in the petition for review process. I say I'm way over, so I'm happy to stop whenever. But I do have one other point I did want to make on the statute, and it goes to the zone of interest point. I think because
go ahead and make that point, and then we'll go ahead and make that point, and then we'll hear from the other side.
Because even recognizing that even if the individual's claims are channeled, they're still the organizations. We lay out in our briefing why we don't think they have standing, but putting aside the standing point, just the zone of interest point I think is an important one. It's a low test, but it's not a toothless test. And I think what the district court did here, it relied on 1158 D4, and plaintiffs repeat this argument on appeal. And D4 provides that organizations, or the attorney general, has an obligation to inform individuals in proceedings seeking asylum that they may be represented by counsel and to refer them to organizations whose job it is to, or mission is to represent these individuals in proceedings. And that provision cannot, I think, show that that Congress intended to protect the interests of organizations to represent third-party aliens, because there is a provision D7 later in the statute that specifically says that nothing in this subsection shall be construed to create any substantive or procedural right or benefit legally enforceable by any party against the United States. So even if we get past the jurisdictional and standing points, I think the statute pretty clearly shows Congress did not have an intent to provide a protectable interest under this statute to organizations.
So one final question on that. If the individuals get past the, and you'll resist the premise, but just bear with me. If the individuals get past the jurisdictional bars that you've asserted and they have standing and you don't contest the individual standing and they fall within the zone of interest, does it matter if the organizations don't?
No, I don't think it does. I think this court's case is, I'm just relying on this court's cases. If you have one party with statutory jurisdiction and standing, then I think that's, under this court's case, is enough.
Okay. Thank you, Mr. Revani. If my colleagues don't have further questions for you at this time, we'll give you some time for rebuttal. We'll hear from Appellee's counsel, Ms. Saharia.
Good morning, and may it please the court. Amy Saharia of Williams and Connolly for the OA plaintiffs. With the court's leave, plaintiffs have divided argument time today. I'll address the issues related to statutory jurisdiction with respect to the individuals. Mr. Reich, on behalf of the SMSR plaintiffs, will address the organization-specific issues and then the merits. Plaintiffs' claims here are quintessential APA claims arising from agency rulemaking that are within the court's federal question jurisdiction. The government's argument that Section 1252b9 strips the court of jurisdiction over these claims is wrong for the simple reason that the claims do not arise from removal proceedings. In the alternative, if the court were to conclude that the claims do arise from removal proceedings, at least some of the plaintiffs, they arose from expedited removal proceedings, and the court would have jurisdiction under subsection E3. Now, let me start, if I may, with Section 1252b9. I heard the government describe Section 1252 as a comprehensive review scheme. In fact, that's not the way the Supreme Court has described Section 1252b9. In the most recent DACA decision, the court described this as a targeted, narrow provision. And it is part of a provision, Section 1252, that both the Supreme Court and this court consistently have read against the backdrop of the presumption in favor of judicial review. We know from the Jennings plurality opinion, which I think the court in DACA largely adopted, that the relevant question under Section 1252b9 is whether the legal question presented by the case arises from an action taken to remove an individual or from a removal proceeding. And the focus is on the legal question, Justice Alito emphasized that in footnote 3 of his opinion. The legal questions here arise from agency rulemaking that renders a class of individuals categorically ineligible for asylum, no matter how they apply, whether they apply affirmatively outside removal proceedings or whether they apply defensively within removal proceedings. And plaintiffs' claims here existed before and independent of their removal proceedings. Their claims existed once they crossed the border with the intent to apply for asylum and were subject to a rule that rendered them categorically ineligible to obtain asylum. The government focuses on the fact that none of the plaintiffs in this case applied affirmatively, and that is for the simple reason that they were apprehended before they had the opportunity to do so. But the fact that that apprehension forced them to raise their claims defensively changes nothing about the legal nature of those claims. The legal claims are the same for our plaintiffs and for individuals who would have applied affirmatively for asylum after crossing the border. And that is something that happens with some frequency. If someone is not apprehended and enters the country outside of port of entry, their mechanism to obtain asylum is to apply affirmatively.
So can you address the argument that was made that if you have an affirmative application for asylum, that where the person is not yet in removal proceedings, that there's either an exhaustion or ripeness problem with that?
Sure. So if someone is not in removal proceedings and applies affirmatively for asylum, what happens when asylum is denied depends on their status. So if they are If they are here unlawfully, then they would then likely be referred to immigration court, where they could then re-raise the asylum claim. If they are here lawfully, then I agree with Mr. Uveni that there is not normally a mechanism for them to seek review of their individual determination, because there's no final agency action. But I think that just illustrates why the government's position here cannot be correct, because a plaintiff in that situation would have no mechanism to bring an APA claim challenging the validity of agency rulemaking. Again, a quintessential APA claim that would render that person ineligible, categorically ineligible for asylum. And there would be no mechanism for them to bring that claim, which is exactly the kind of circumstance that courts have looked to, for instance, in Jennings and McNary, to conclude that this is not the kind of claim that Congress intended to channel through Section 1252b9.
On the other hand, your claim is a facial challenge. So it includes, that's a subset of the individuals who are affected by the rule. But what about all the others? And what about the felons? And what about all of the other various people who are excludable?
Well, I guess I'm not understanding the question as it relates to felons. Those people were already ineligible for asylum, but the claim here, it is a facial claim.
But they can apply. They can apply for asylum, correct?
They can apply for asylum. I think that as Judge Bybee explained in the Ninth Circuit proceedings, the distinction between applying for asylum and eligibility for asylum is really a hollow distinction. And if I may, I'd like to refer the merits questions to Mr. Reich, who is prepared to address the merits questions. But with respect to statutory jurisdiction, these people, all of these plaintiffs, were categorically ineligible for asylum and otherwise would have been eligible. None of the plaintiffs are felons, for instance. And so this is a facial challenge to the rule brought under the APA. And again, it's a rule that would affect them whether or not they were ever in removal proceedings. And I think that's why this case is very much like the DACA decision that Judge Srinivasan mentioned. Just like asylum, DACA status could be a defense to removal. In that case, the government argued that its rescission of DACA was the first step taken to remove these individuals. And so even though that issue perhaps might be adjudicated in some future removal proceeding, whether the rescission of DACA was lawful, the court nonetheless had no trouble holding that it did not fall within Section 1252b9.
I mean, I think you don't dispute the proposition that the claim that's being asserted here by your clients could be asserted in a removal proceeding. Your point is that even if it could be, it doesn't have to be.
Exactly. I do think it would be quite difficult to assert this claim in a removal proceeding for two reasons. First of all, individual immigration judges don't themselves have authority to rule that agency rulemaking is invalid in contravention of the INA or not promulgated pursuant to notice and comment rulemaking. So I do think there's a question about whether these claims could even be adjudicated within the agency.
That is not an argument against jurisdictional exhaustion. And that's the case I mentioned to counsel for the government. It's Avocados Plus that held that when there's jurisdictional exhaustion, even if the agency or whatever body within the agency has no authority to declare something unconstitutional or illegal, whatever, you still have to raise it.
Well, it is one of the factors that courts look to under the Thunder Basin test. Now, it's not, which we don't think applies here, but it's not a dispositive factor, of course. I think the other relevant issue is Section 1252b4, which is part of the same statute. And Section 1252b4 limits a court of appeals on a petition for review to the record of the individual removal proceeding, which in an ordinary case would not include the record of agency rulemaking. Now, of course, there are procedures that require the government to come forward with that record in APA claims in federal court, but the government has cited no requirement that would require the government to come forward with that record in individual immigration proceedings. The most it has offered is that these individual asylum applicants, the thousands of them, many of whom are pro se, could somehow agree with the government in the course of these immigration proceedings to get that record, to put it before the IJ as a formality, since the IJ can't him or herself decide these APA claims, so that it would be preserved for a court of appeals on a petition for review. And I think the fact that Congress included that in Section 1252b4 is a very good indication that Congress did not intend for these kinds of classic APA claims to be adjudicated on a petition for review. I see I'm out of time. If the court has further questions, I'm happy to take them. Otherwise, I will pass the virtual podium on to Mr. Reich.
Unless my colleagues have other questions, doesn't sound like they do. Thank you, counsel. We'll hear from Mr. Reich.
Good morning, Your Honor, and may it please the court. Mitchell Reich for the SMSR plaintiffs. Ms. Zaharia was just discussing the reasons why we believe that the individual plaintiffs have properly invoked this court's jurisdiction. And before turning to the merits, I want to briefly discuss a separate and independent avenue for this court to review the plaintiffs' claims. There are two organizational plaintiffs before this court, Raices and Care Coalition, that have submitted detailed and uncontested declarations explaining that the challenged rule will frustrate their ability to carry out their mission and require them to divert substantial resources in order to counteract that harm.
Can I just ask you the threshold, the same question I asked Mr. Raveni, which is if the individuals do have standing and are within the zone of interest and the jurisdictional bars don't preclude them from going forward, and I know that the government disputes that, but I just want to engage on the premise. If that's true, then does any of the points you're making about the organizations matter?
No, these are two separate and completely independent avenues for this court to exercise jurisdiction. As Judge Moss recognized, if you found we were correct on either one, you could reach the merits of the claim, and the relief that the court would award would be exactly the same. Okay. And I want to discuss the organizations briefly because I think that the government's, even if the court thought that the government's jurisdictional arguments had some merit with respect to the individuals, which for all the reasons Ms. Zaharia laid out, we don't think they do. We don't think they have any merit with respect to the organizations. Judge Moss concluded that below. Judge Kelly concluded that in the closely related Care Coalition case. And indeed, in the district court, as noted in footnote 6 of the district court's opinion, the government didn't even argue the organizations were subject to the jurisdiction channeling scheme. And I think it's pretty obvious why. That scheme, as the Supreme Court said in INS v. St. Cyr, is designed to consolidate and channel claims that arise in removal proceedings for review on an appeal from a final removal order. That it's not a scheme to strip jurisdiction over any claims that arise outside removal. And I think Mr. Raveni, in a sense, gave the game away when he acknowledged that this scheme would not preclude an individual alien from asserting a challenge to this rule if they pressed an affirmative asylum claim. He suggested there might be other finality and ripeness problems, but he acknowledged that this jurisdiction channeling scheme wouldn't apply to that claim. And I think that's an acknowledgement. This is not a comprehensive scheme for reviewing certain legal questions. It's just a scheme for reviewing questions that arise in removal. So organizations whose claims don't even plausibly arise within the removal process, after all, these organizations aren't themselves subject to removal, and their claims would exist even if no removal proceedings were ever brought. I think that demonstrates that their claims can't be precluded. I'd also note that Mr. Raveni said that there was no one before the court who could possibly assert the interests of persons filing affirmative asylum applications. That's not correct. Raices, in paragraph 29 of its declaration, explains that it represents at least 100 applicants a year filing affirmative asylum applications. And all the harms identified in Raices' and Care Coalition's declarations that give them standing and place them within the zone of interest apply as to those individuals. This rule makes it substantially more difficult to counsel those individuals, to represent them in asylum proceedings. It would be more time consuming to represent them. They'd have to represent the children separately because they couldn't be derivative beneficiaries of their parents. And so even if no removal proceedings were ever brought against these organizations' clients, they would still have these claims because they would still be harmed by the rule. And that is sufficient to conclude they're outside the jurisdiction channeling scheme. I'd also like to note as to zone of interest, Mr. Raveni suggested that these organizations don't have what he referred to as a cause of action under 1252. I think that's just a conceptual error. These organizations have a cause of action under the APA. They don't need to find a separate one under 1252. The only thing they need, or under 1158, all they need to show is that they're within the statutory zone of interest. And that permissive test, as Judge Moss explained, is easily satisfied here. The interests the organizations are asserting is the very interests the asylum laws protect. That is, helping people file meritorious claims for asylum. They don't need to show that they themselves are the intended beneficiaries of the statute. That's the teaching of the Supreme Court's cases in Patchak and NCUA, and of many of this court's cases. And they don't need to show that Congress contemplated suits by these particular organizations. I think the fact, though, that Congress in 1158d4 specifically pointed to organizations like these and made sure that asylum applicants could be represented by them just shows that the interests of the organizations are aligned with those of the asylum seekers, and that's vaults them far beyond the threshold to fall within the zone of interest. Turning to the merits, this whole jurisdictional discussion, as the district court said, is a very long backstroke for a very short putt. The text of section 1158A1 provides that any alien who enters the United States, whether or not
if that's the case, if the backstroke is too long for the short putt, the putt will be missed.
I think Judge Moss's point
is the district court missed the putt, of course, yeah.
I think he got the putt just right. I think it's a clear shot from the statutory text to the result, which is that section 1158A1 says that any alien who enters the United States, whether or not a designated port of arrival, and irrespective of their status, may apply for asylum. This rule says that an alien who enters the United States outside a designated port of arrival is ineligible for asylum. And I think, Judge Randolph, your question hit on the central flaw in this rule is that it would deprive the rights to apply for asylum, irrespective of status, in 1158A, functionally meaningless. It would essentially write it out of the statute. And under 1158B2C.
Why is it write it out of the statute? You know, all the people that are coming through ports of entry are still eligible and they can apply. And there are all kinds of barriers. There's, you know, where people are declared ineligible, aliens declared ineligible for a whole variety of reasons and have been for a couple hundred years. See the Supreme Court's opinion in Kleinis versus Mandel. And those people, you can say, well, it's read out of the statute. They all can apply, but huge subsets of them are ineligible.
Yes, Your Honor. And our argument is not that the right to apply guarantees eligibility. It's that the right to apply, irrespective of status and whether or not you entered at a point of entry, guarantees that you won't have an application denied on that exact characteristic. Terrorists, criminals, as Judge Bybee observed, there's no right to apply irrespective of whether you're a terrorist or a criminal. So there's no conflict between the statutory rights and the eligibility bars for them. But there is a right to apply whether or not you entered at a port of entry.
Let me put the direct question to you. Take my hypothetical where an individual is swimming the Rio Grande for the second time and gets caught. And that person has committed under the statute, what is it, 1385, I forgot, has committed a felony. And what's the argument why that person is entitled to eligibility for asylum?
That person might not be entitled to eligibility, but this rule of decision, as Judge Bybee put it, would still be unlawful as to them, because the characteristic that would be rendering them ineligible under this rule is their unlawful entry outside a port of entry. The government might be able to deny them asylum on a separate basis, and that might be totally lawful. I'd also note that
but the felony is the entry in a place other than a port of entry. That's the felony. Person's totally clean otherwise.
2 points, Your Honor. First of all, I don't think it's true that any alien who commits a felony is automatically ineligible for asylum. I think the provision you're pointing to is the one saying that someone who commits a serious crime is ineligible for asylum, and that's often a case-by-case determination. It wouldn't necessarily be the case that unlawful entry even second time would render someone ineligible for asylum on that basis. But even if it did, the government could remove them because they committed a crime. It cannot could deny them eligibility because they committed a crime.
Every person that enters the country in a place other than a port of entry is committing a crime. Every single one.
Yes, Your Honor, but that may be the case, but still the protection in section 1158A1 is that alone, that unlawful entry alone, cannot be the basis for categorically rendering someone unable to seek asylum. That's the protection Congress put in. And indeed, much of the asylum system is built around the premise that people who are here illegally can still seek relief from removal. That's what asylum is there for. That's what the expedited removal scheme, the entire credible fear screening process is for. The persons who recently entered unlawfully can still assert protection from removal on the basis of asylum.
So they can get asylum, but they have to serve 6 months in prison before they can get out. Is that right?
That may be true, and I think that just shows that there's a lot of tools in the government's toolkit here. If it wants to deter unlawful entry, if it wants to penalize these persons, it can also try to enter a third country agreement with the countries these aliens came from. There's a lot of powers in the asylum laws.
Yeah.
But one power that there is not is that 1158B2C says that any bar on eligibility must be consistent with this section. That is consistent with 1158 as a whole, and that includes the very first protection in the statute, the right to apply irrespective of manner of entry.
Yeah. What is the status of the proclamation now?
The proclamation, the most recent proclamation, provided that it would remain in force until 90 days after the Ninth Circuit's injunction was lifted. So it still remains in effect. And I actually think that highlights a separate legal flaw with this scheme that the government has come up with. What determines whether aliens are subject to this eligibility bar is whether the president decides they will be. He determines whether there is a proclamation that triggers this rule, how long that proclamation lasts. The rule says he can make exceptions to it for persons who are not eligible for asylum. And
well, that leads me to my next question. And this is a pure hypothetical. Let's suppose that the Biden administration, if it becomes an administration, the first day, January 20th, repeals or whatever the proclamation. Does that moot this case?
Your Honor,
if not, why not?
Your Honor, we think it would be entirely appropriate for the courts to hold this case in abeyance pending the inauguration to see what happens. I think we would need to see the content of the proclamation to determine whether it truly moots the case, whether there's no chance of any legal relief. It would determine on exactly what he said. The rule itself might be hanging out there. I think we would want to see what it says and submit filings to that effect and discuss what the result was. But we think
that's fair enough. Yeah,
and so
it's possible that that a new incoming administration could moot the case.
It's entirely possible, and I think the Biden administration, to my knowledge, has indicated that they are planning to withdraw many of the current administration's asylum policies. So I think there's a good chance that will happen. And in interest of judicial efficiency, it might be appropriate to wait.
Can I ask a question about the merits? So unless Judge Randolph has a follow-up question on that, along those lines. On the merits, if the statute said 1158A1 that instead of irrespective of such alien status, it said irrespective of such alien status, including whether they have been convicted of, I'm looking for the exact word, a particularly serious crime. And then the statute still had B2A Romanet 2 about a particularly serious crime. Would you just say, well, that statute's just completely internally inconsistent, it makes no sense? Or would it still make sense because the first provision deals with application and the second provision deals with eligibility?
It would make no sense. There's no delta after 2 years of litigation that the government can identify between a bar on applying and a bar on eligibility. There's no separate benefit conferred by the right to apply other than the possibility of being eligible. And both bars on applying and eligibility are applied at the same point in the process by the same officers and have the same result. And I would just note that this rule, the government sort of floated the possibility bars on application are a screening tool and bars on eligibility somehow come in at the back end. As I just noted, in practice, that's not true. They are applied simultaneously. But this rule actually provides that unlike every other bar on eligibility, asylum officers should apply this rule at the quote threshold in the words of this rule. That is, when an alien asserts a fear of removal in their credible fear screening interview, the very first question the government must ask, the asylum officer must ask, is whether they're subject to this rule. And if they are, they have to have asylum denied. So even by the government's definition, this rule functions as a screening tool, as a bar. It walks and quacks like a bar on applying for asylum. So even if there was some non-existent functional distinction, I think this falls on the wrong side of that line.
Okay, thank you. Let me see if my colleagues have further questions for you, Mr. Reich.
No.
Thank you, Mr. Reich. Mr. Ravani, we'll give you 3 minutes for your rebuttal that you asked for.
Thank you, Your Honor. I'll be brief. So just a couple points in rebuttal. First, Ms. Saharia refers to the DACA case, Regents, and I think we've discussed this a little bit, but just to close the loop on it, the court there has one paragraph. I'm looking at the decision now, and it essentially adopts the standard from Jennings in the plurality there. And that case is just different than this case. DACA has nothing to do with whether someone is eligible for relief from removal. It's a policy that applies entirely prior to and antecedent any sort of removal proceeding.
But can't you? But she made the point that but she made the point that DACA could be asserted in a removal proceeding. Is that not true?
You're not. Once you're in removal, you're not getting your DACA back. No, that's not correct. You could get relief from removal, and then many months or years later, you could apply for DACA again if DACA still exists at that time. But once DACA is rescinded, you're not going into the immigration court and arguing you should give me DACA back. And I think that dovetails with the point that Mr. Rice just made. What is the point of making someone apply for asylum if they're just going to be denied? It's not correct that it's a null set. When you apply for asylum, you're eligible for work authorization. And then as you go through your removal proceedings, which take weeks or months or years, you have work authorization. So that's a specific benefit that connects to an application that even if you're ultimately ineligible for, you can get while your application is pending. Just real quickly on the record-making point that Ms. Saharia raised. And this is something I think Judge Moss relied on as well, and I think it's wrong. The fact that the immigration judge can or cannot make a record is not really the dispositive point under these claim channeling cases. The dispositive point is, can the Court of Appeals get the record? And the Court of Appeals absolutely can. 1252A says that these proceedings are governed by the Hobbs Act, and then it specifically carves out 28 USC 2347C as something the Court of Appeals can't do, that is take new evidence, but then that leaves in place 2347B, which allows the Court of Appeals to send the case to the district court to get a record. Also, I mean, part of this is just self-inflicted. Plaintiffs don't want to go through the removal proceedings, but nothing stops them from asking the IJ to produce the record or require the government to produce the record in those proceedings. So the issue on the record is, I think, a red herring.
The statute itself may provide, because I don't have it in front of you, but I thought the language was the administrative record on which the order of removal is based. And if the alien has raised an asylum claim, including that the regulation is invalid, then one could say that the administrative record for the regulation is part of the administrative record on which the order of removal is based. So
that's right, Judge Randolph. And just because plaintiffs choose not to ask to submit that record or require the government to submit it for the proceeding doesn't mean it can't be submitted. And last, this wasn't cited in our briefs, but it was cited in the Supreme Court single Justice O'Connor's decision that we do cite in our briefs. It's this court's decision in Ayuda, 7F 3rd 246 at 250, and that is sort of like that case is after years of litigation involving IRCA and SAW, the issues in McNary and Catholic services, which we cite in our briefs, and essentially it has two key holdings on a scheme that was even less restrictive than this one. It said that individual aliens must raise their claims exclusively in the Court of Appeals, and then it separately said it follows then that an organizational plaintiff could not undermine the statutory scheme by suing to challenge INS policies or statutory interpretations that bear on an alien's right to legalization, end quote. So I think that case is directly on point to a number of the issues here. And if there are no further questions, thank you.
Thank you, counsel. Thank you to all counsel this morning. We'll take this case under submission.
This honorable court is now adjourned until Wednesday, December 9th at 9:30 a.m.